Hello, everyone. I am Cindy Jiang, the partner of AllBright Law Offices, Guangzhou. Today, my colleague Steven Shi and I will shed some light on the key points of foreign-related inheritance practice in China. Due to the impact of COVID-19 pandemic, the demand for inheritance legal services has significantly increased in recent years, and the inheritance involving foreign parties or other legal factors outside China is the most complex sector therein. As in most cases, lawyers will not only deal with basic issues of general inheritance in light of the civil code of the PRC, but also need to handle various difficult issues, such as the applications and conflicts of laws in different jurisdictions, the correspondence of multiple identities and the nationalities of the parties involved, and the foreign exchange control on remittance of the proceeds of the estate, etc. It is always the case that a slight move in one part brings a domino effect to the whole picture. Therefore, it requires a high level of professional skills, global awareness, and even business mind for lawyers.
In the following, we will introduce the general principles and practical difficulties of foreign-related inheritance in China by 4 parts, including inheritance types, inheritance methods, determination of 3 key elements of inheritance, and practical difficulties. Let's start with the first part. Like in most countries and regions, inheritance under the Chinese law is also classified into 2 major types: testate inheritance and statutory inheritance. In testate inheritance, a will made overseas usually needs to be notarized and authenticated with the probate granted by the foreign court, where the will was executed before it can be used in China. In statutory inheritance, the estate is generally distributed equally among all heirs, and they may also agree on an unequal distribution. In foreign-related inheritance, regardless of the inheritance types, the heirs must obtain valid legal documents through either of the following inheritance methods to inherit the estate in China.
The first one is notarization inheritance, in which the heirs should apply for an inheritance notarization certificate with a Chinese notary office and obtain the estate accordingly. This method usually is adopted by the heirs who can reach consensus on the estate distribution. The second one is litigation inheritance, in which the heirs should file a lawsuit with a competent people's court and obtain the estate according to the judgment or court mediation document. This method is mainly applied where disputes among the heirs on the estate distribution, or some heirs cannot be identified or even have lost contact.
Next, we will introduce the determination of 3 key elements in foreign-related inheritance, including heirs, estate, and distribution. For the determination of the heirs in foreign-related inheritance, generally, they are determined based on the valid will or probate in testate inheritance, and determined by the governing law in statutory inheritance. Under the civil code of the PRC, statutory heirs including 2 categories. The first category includes parents, spouse, and children, and the second category includes siblings and grandparents. In statutory inheritance, the estate is firstly inherited by the first category, and if not, by the second category. Each statutory heir in the same category is entitled to an equal share of the estate.
Most foreign-related inheritance cases involve the property acquired by the deceased during marriage. Since different jurisdictions may take different approaches on whether this property constitutes joint property of the spouse, it is very crucial to firstly sort out the nature of this property in determining the scope of estate. According to the law of the application of laws to foreign-related civil relations of the PRC, the parties may choose the applicable law on their marital property relation among the laws of the habitual residence, the nationality of one party, or where the main property is located. If the parties have not made a choice, the law of the common habitual residence shall apply. If no common habitual residence, the law of the common nationality shall apply. For your better understanding, we would like to give you an example. Tom, the deceased, and his wife Eva have the same nationality of Singapore. During his marriage, Tom purchased a house in China in his own name and deposited 1 million yuan in his personal bank account in China. Tom and Eva did not sign any written agreement on their property relations, and Tom did not leave any will during his lifetime. Since they have not chosen the law applicable to their property relations, the governing law thereof should depend on their common habitual residence. In second scenario, if their common habitual residence is Singapore, according to Singapore law, the property in one's name generally is the personal property rather than the joint property of the spouse. Therefore, both Tom's house and the bank deposit is his estate. In scenario 2, if their common habitual residence is China, under the civil code of the PRC, except otherwise stipulated, the property acquired during the marriage is the joint property of the spouse. Therefore, 50% of Tom's house and bank deposit is Eva's personal property, while the remaining 50% is Tom's estate.
Unlike testate inheritance in cross-border statutory inheritance, after determining the scope of the estate, it is necessary to distinguish the respective governing laws of movable property and immovable property, and ultimately determine the distribution method for each item of the estate. Specifically, under the Chinese law, the distribution of immovable property will be governed by the law of where it is located, while movable property such as bank deposit and securities will be governed by the law of the deceased's habitual residence at the time of passing away. Let's get back to the first scenario of Tom with his habitual residence in Singapore. His estate will be distributed by the following 3 steps. First, Tom's property relation is governed by the law of Tom's habitual residence, which is Singapore law. So all the property in his name is estate. Secondly, the distribution of the house is governed by the law of where the immovable property is located, which is Chinese law. So the house will be distributed to his statutory heirs. Lastly, the distribution of movable property like bank deposit is governed by the law of Tom's habitual residence when he passed away, which is also Singapore law. So the bank deposit shall be distributed according to the respective Singapore law.
As you may see from the above, without considering inheritance disputes, the practice of normal foreign-related inheritance is already very complicated, and the inheritance involved overseas trusts is even more difficult due to the fact that overseas trusts were not established and licensed under the trust law of the PRC. Usually, they are not recognized by Chinese governmental departments and are not allowed to hold properties or open bank accounts in China. So it is very hard for overseas trusts to take over the Chinese estate of the deceased in their own names, or legally remit the proceeds from the estate out of China. Fortunately, we have explored alternative solutions on such cases and could provide tailor-made solutions and handle relevant practical matters on a case-by-case basis.
Well, that's all for this topic. We hope it will be helpful to you.
And we are looking forward to meeting you in AllBright Law Offices, Guangzhou.